Hello, this is Captain Chaudhari. Today I'm going to talk about the difference between the Hague Visby Rules and Hamburg Rules in respect of various aspects such as the application of the rules, the period of responsibility, as well as the freedom of contract. The Hague Visby Rules specifically state that the provisions of these rules will apply to every bills of lading in respect of carriage of goods between the two ports in different countries, provided one of the following three conditions is satisfied. One is the bills of lading is issued in a party state, that means contracting state. Number two is the cargo is loaded, the goods are loaded from a party state. The third point is the contract evidenced by the bills of lading. We know that the bills of lading is a good evidence to the contract of carriage. So it says the contract evidenced by bills of lading provides that these rules or the national legislation which gives effect to these rules, will govern the contract. So these are the three conditions in which the Hague Visby rules can apply regardless of the nationality of the individuals, nationality of the various entities involved. The Hamburg rule enhances the application, the scope of application further because it includes a few more conditions under which the Hamburg rules can be applied to the carriage of goods. It says that the provisions of these rules will apply to all the contracts of carriage, all the contracts of carriage by sea between the ports of different countries, right? Provided one of the following conditions is satisfied. So these conditions are: number one, the port of loading is in contracting state. Number two, port of discharge is in contracting state. Number three, if there are different ports of discharges which are given in the contract, then one of the actual discharge port is in contracting state. So we've seen that where in Hague Visby rules there was no mention of port of discharge being a contracting state. Here the port of discharge, or if there are several ports of discharge, even if one port of discharge is in contracting state, we can apply Hamburg rules. So there is a condition similar to Hague Visby rules. It says that the bills of lading or another document which evidences the contract of carriage by sea between the ports of two different countries, this bills of lading is issued in contracting state. And yet another condition is the bills of lading or other document evidencing the contract of carriage by sea provides that the provisions of this convention or national legislation giving effect to the convention, that means Hamburg Convention, are applied to the contract, govern the contract. And of course the provisions of this convention are applicable without any problem, without any regard to the nationality of the relevant entities. Our second point under which we will compare the two rules is charter party. Just that there is a charter party is not enough that any of these rules will apply, whether Hague Visby rules or Hamburg rules. Just the charter party is not enough. Automatically these rules will not apply to the carriage of goods. However, if the bills of lading is issued pursuant to the charter party, then we can say that the provisions of these conventions, whether you talk about Hague Visby rules or Hamburg rules, can apply. Our next heading is the period of responsibility. Under Hamburg rules, it is stated that the responsibility of carrier starts from the time he takes charge over the goods, and that is in the load port and in discharge port when he loses the charge. So it can be said that at load port, whenever he takes over the goods from consignee or his representative, and also the sailing time, and at discharge port thereafter when he hands over the goods to the representative of consignee or consignee himself, this is the period of responsibility. Now this period of responsibility is less in Hague Visby rules, which means that Hamburg rules have actually increased the responsibility of the carrier. In Hague Visby rules, it is stated that when the cargo is loaded and thereafter when the cargo is discharged, and of course during the sailing, it is the responsibility of the carrier. So typically for dry commodity loading or general cargo kind of loading, it is said that it is from tackle to tackle. It's a very famous thing in respect of Hague Visby rule, tackle to tackle. So I suppose the tackle to tackle thing is when you have ship's gear loading the cargo. But when it is the shore crane that is used for loading the goods, then it can be from railing to railing. Our next heading in respect of the differentiation between the Hague Visby Rule and Hamburg Rules is deck cargo. To understand what is the difference in respect of deck cargo, let us first understand what is the definition of goods as is given in Hague Visby Rule. It's a very strange definition. You wonder why such a definition. So a reader must understand how and why the goods has been defined in this fashion. So goods includes goods, wares, merchandise and article of every kind. Every description whatsoever. But it does not include live animal and the goods which are loaded on deck, and it is stated in the contract of carriage, etc. or bills of lading that it is loaded on deck. So it is a reverse kind of definition, like what is not goods. It says that if you have loaded something on the deck and you have stated in the contract of carriage or bills of lading that it is loaded on deck, then it is not goods. What it means is then Hague Visby rules do not apply to that goods which are loaded on deck. It means that when you load something on the deck, when you load something on deck under Hague Visby rules and master or the carrier is not careful enough, he is not cautioned enough to have another agreement with the shipper or stipulation in the bills of lading that his responsibility is such and such in respect of the deck cargo, he can be in big trouble, because then Hague Visby rules don't cover you. Then your liability can be unlimited in case of damage. So it is the responsibility of the master that when he loads the goods on deck under Hague Visby rules, he has some special stipulations in the bills of lading, right, or a contract with the shipper in respect of the responsibility in respect of the goods which are loaded on deck. Hamburg rule says that you can carry the goods on deck or you can also carry live animals provided one of the following three conditions is satisfied. Number one, it is required statutorily. That means there are regulations which require that you must carry a particular goods on the deck. Number two, you have an agreement with the shipper. You have a special agreement, like carrier has invoked an agreement with the shipper that the cargo is carried on deck, and he should make an entry in the bills of lading or the similar document evidencing the contract that the goods are being carried on deck under the special agreement. Thirdly, it could be in accordance with the usage of that trade, that the goods are carried on deck. Now when the goods are carried on deck against the provisions of the rules or without the contract that I just now talked about with the shipper, then the carrier might be responsible for the damage, loss or delay which is caused solely because the goods were carried on deck. Also, if there is an express provision that the goods must be carried under deck and the carrier carries the goods on deck, this would be considered as a reckless activity from the carrier, which means that the carrier might lose the right to limit the liability in case of damage. Next heading to discuss is freedom of contract. When we talk about freedom of contract in Hague Visby rules, straight away what comes to your mind? It is Article 3, Paragraph 8. It says that any contract, any agreement which will relieve the carrier from the liabilities which are stated in the rules is null and void. That means you can't have any agreement between the carrier and the shipper or in respect of carrier's responsibility whereby his responsibilities will be reduced. His liability, his responsibility to take care of the cargo or the liabilities which can be imposed on the a carrier can be reduced, will be null and void. We can increase the liability of or limit of liability of the carrier. That's a separate story, but you cannot reduce the liability of the carrier. That is what is stated in Article 3, paragraph 8. So talking about freedom of contract under Hague Visby Rules, we must also look at what Article 6 says. Article 6 says that there might be a situation where some consignment that is carried is not ordinary commercial shipment. In such carriage, bills of lading may not be issued. Bills of lading is not issued, but there is a receipt that is issued which has got legal standing, right? So there can be another set of liabilities, responsibilities, etc., which the carrier must comply with. Now there is this Article 7 also, which is also in respect of freedom of contract. But as we have said that Hague Visby rules apply tackle to tackle. So before tackle, that means before loading a cargo or after discharging the cargo, carrier can enter into a separate contract. There is a freedom of contract. So there can be different conditions, but this happens before loading or after discharge. So once again, there is a freedom to contract. So under Hamburg rules, when we talk about the freedom of contract, it is rather restricted. It says under Article 23 that if there is any stipulation or a contract, and it derogates the provisions of Hamburg rules, then that stipulation or the agreement is null and void. Or it is null and void to the extent that it derogates from the original convention or the provisions of the convention. So as we know, Hamburg rules is slightly, pro cargo owners. So it says that if there is any provision, that is otherwise null and void. This way, if it is null and void and then some loss happens, then for the loss, the carrier must compensate. Now, when we talk about derogating the convention, it also says that it is possible to increase the responsibilities of the carrier. No, that will not be considered as a derogation if it is agreed, if the agreement is made in this respect. But otherwise, anything that derogates the provision of the convention is null and void.